हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
Constitution. Priyasha, are you here? Are you in present in class today? Priyasha? Okay, now we were looking at Article 1 of our Constitution. It says, India, that is Bharat, shall be a union of states. In my class yesterday, we went through the distinction between federation, confederation, and why India is neither a confederation nor a pure federation. Okay, and we noticed that in a pure federation, the central government and the state government are coordinate and independent, and that is called coordinate and independent. And therefore that is the basis in which we would be able to decide whether or not whether or not the Indian Constitution creates a federal form of government or is confederal. In confederal, the central government is dependent. It is not independent. It is dependent on the different states. And I've taken the earlier example of the US before the Constitution, between the Declaration of Independence in 1776 in that country to the adoption of the Constitution in 1787, and it's coming into force a couple of years later. Now, that in that 13-year period, it was a confederation where the central government was dependent for its powers on the different states. If it were a true federation, then the central government and the state government, based on the federal principle, would be independent as well as can you now hear me, Priyasha? Yeah, Priyasha, I was wanting to tell you that the invitation that I sent out yesterday, that link did not seem to work, so I've had to send out a fresh link now. The reason I did it, and I want to explain to whoever is here, I'm very happy to have other students in my class. I have no problem. This is not my private property, but so third section is students of Campus Law Center have the right into my class. It should be to enter, and therefore that's the reason. So now can you hear my voice, Priyasha? Just so that, because you're the class representative, I want you to explain what I am doing. Can you all hear me?
Yes, ma'am.
Yes, ma'am. Great. Okay, thank you. So now let's continue our discussion of Article 1. That is the Union of States, and therefore we are not federation. We are quasi-federal. And if you remember, I had asked you to look at the S.R. Bommai judgment, where the different phrases had been used. Amphibian, which you'll agree is extremely a colorful phrase, looking land and water, that there is a bias in favor of center. And therefore, by and large, we talk about a quasi-federal constitution that sometimes, depending on situations and contingency, can become a little more unitary, that's specific to a particular circumstances. But in general times, we are not purely a federal constitution, even in normal times, non-emergency times, non-special times, there is a great bias in favor of the center. Now, in order to understand that, I had asked you all to read West Bengal versus Union of India. How many of you have read it? Just say yes. How many of you, let me ask the reverse question. How many of you are having read West Bengal. How many of you have come into class without reading? No, don't say yes. How many of you have not read it? I want to know that. Everybody has read it? Everybody has read it. Divansh, you've not read it. Nikhil has not read it. Who else has not read it? Pradeep, Sharan, Kapil, Sangeeta, Kanwar, Dipanshu. May I know why? Half? No. Okay. Not good. You shouldn't come into my class like this. Okay. Now what I'm going to do is I'm going to call on various people and I'm going to take that. I want a presentation. So I'm going to first ask Anya Singh, who is present, who is going to tell me what is the quorum of particular judgment. Just take a shot at it. Anya Singh, where are you? Okay, it's okay. Don't bother. Don't keep crawling up my chat box. Leave it. Anya Singh, are you there? Anya Singh. Can you hear me, Anya Singh? Okay, Afreen Mewati. Afreen Mewati, are you there? Afreen Mewati. Anya Singh, are you there? Okay. Abhishek Anke Chaudhary, are you there? Abhishek Chaudhary. Are you there, Abhishek? No. Abhishek Bhushan, are you there? Okay, then let me ask Ajay Reddy, are you there? Ajay Reddy? Okay. Akanksha Sharma, are you there? Okay. Akshay Seal, are you there? Akshay Seal? Okay. Okay, who has read the case? Who can tell me the quorum?
Ma'am, I can.
Who is that, please?
That's Aman, ma'am.
Aman. Yeah, Aman, where are you, Aman? I can't see you. Aman, okay, Aman, tell us who is the quorum.
Ma'am, it was a 6-judge bench headed by D.P. Sinha, Chief Justice.
Okay,
Also
now,
sitting with him.
Just hold it right there. Why do you think it was a 6-judge bench? Have you ever come across a 6-judge bench before?
Oh, no, ma'am. This was the first time I saw a 6-judge bench.
Yeah. Why do you think we had a 6-judge bench? Just take a.
Ma'am, honestly, I can take a guess, but I don't know the answer to this.
Okay, take a guess.
Ma'am, I suspect because it was a matter of importance and they expected some manner of concurrence on this question. They had an even number. I don't know.
Okay. Now, in the 60s, there had been a large number of 6-judge benches. And I think if you looked around a little closer, you may be able to find an answer. So this is separate from West Bengal versus Union of India. But this is a nice area to do research on. How is it that we had an even number? Because, you could never get a majority. If there was a split down the middle, what would the court have done, right? That's the reason that we normally have odd numbers. But just as an area of research, you will find that in 4th semester, when this class comes to labor law, you will find another very important case, Safdarjung Hospital versus SEPT. And that is actually a very landmark case, and that's a 6-judge bench case. So if as a research question, since it's a tutorial class, I can go off my lecture a bit. I can neither see you nor can I listen to you. Why can you not listen to me? No. Is there some mistake I'm doing? Okay, here is my camera back up. Can you see me now, Priyasha? But Priyasha, what I suggest is disconnect and come back again. Then you can listen to me. Okay. Now, if I put a question to you and I said, how many court cases, because I think we must use this tutorial class to also improve your research and writing skills. I'm very keen that at the end of the semester, each one of you has tried to write or speak in my class. Okay, I'm very, very interested in that. Because you must. I find law faculty students are very, very smart, they're very good. The only problem is the writing skills that we are not really trying to address, and I'm going to try and do it to the best of my abilities. Not saying that's going to be great, but to the extent I can, I would like to. Now, if I put you a question, Aman, how will you know how many 6-judge benches there have been there in Supreme Court? If this was my research question to you, that here is an unusual 6-bench case, how many such similar size benches have been there? How will you research this and find an answer?
Ma'am, I'll first try and look at the provisions of the Constitution that talk about how, I'm not
asking why. I'm not asking why. I'm asking.
Okay, so how will I figure this out?
A factual question. After we get the data is when we'll do our analysis, right? Just how is it? How many 6-judge benches have been constituted by the Supreme Court thus far? How would we research that question? How many? Anybody other than Aman? Anybody who's familiar with our internet resources?
I'm not sure about this.
Speak.
It is just a guess, but in order to find out how many 6-judge benches there have been there, first we can look at the major judgments that deal with the interpretation of the Constitution, because that requires at least 5. And from there, once we've thrown them, I think then afterwards we can look for. It's just a guess.
Okay. Does somebody have another idea?
Ma'am, I have the bare copy of EBC of Constitution of India, at the back of which is given the list of largest bench decisions. So it's given 49. 49.
No, 6-judge bench decisions?
6-judge bench decisions, we have 49 6-judge
so
bench.
How did you find it? You found it from which?
It's the direct Constitution of India.
Yes, but because there could have been more. If you had only internet resources, how would you find it? Because many of you don't have books. You all had to go without any book.
I'm just Aman again.
Okay, Aman, yeah.
I was just looking at SPC online.
Yes.
There you have the ability to filter through quorum.
Quorum, exactly. That's the simple way to do it. If you don't have SCC online, because some of you are not able to access SCC online, using India Kanun. If you're using India Kanun, right away there also. So in Manupatra and in SCC, you would be able to filter it appropriately. Now, you may wonder why ma'am is raising all this in a constitutional law case. This is a tutorial class, and if you are not on top of research tools and research skills, it's very difficult to do meaningful research, okay? So you must go for a tutorial, you must, using your Delhi University email ID, you have to log into, now everybody has offline resources, teachers and students go on to SEC online, otherwise use Indian Kanun and get the number of 6-judge bench decisions that are there. Okay, now Mansi says there are 49 6-judge bench decisions, okay? And Mansi, you will also look and you will find that bulk of them were in the 1960s. Am I right? Was it Mansi who said that there were 6? Which decade are the majority of them in?
1950, 1950, 1950, 1950, 1951.
Yeah.
1952, 1953. Then we have 63, 63, 63, 63, again 62.
Now I'm just giving you one of them were in 1960 because Chief Justice Kanya, immediately after becoming Chief Justice of India in 1950, unfortunately passed away very soon. And then for a longest period, it was not clear who is going to replace him on the bench. So we began with 7 judges. And then for about a year or two, we only had 6 judges on the bench. There was, if you would like to read more, there is George Gadboa's book. I'll just print it out here. Talking about the Supreme Court, there's also Arghya Sengupta's book on appointment of judges, and he tells you the politics and the background why the judges were not appointed in the 50s. So if you have one bunch of 6 judge bench decisions, yet by the time you come to the 60s, there were anyway more than 6. It was not out of necessity, but still we had in the 60s a whole bunch of 6 judge benches. So what I'm saying is that sometimes students come to me and tell me, ma'am, we don't know what to write about. Suggest a topic. It's good to talk to other people and get ideas, but when you read each thing that you read, like why is it that there was a 6 judge bench here, should trigger you, and you can go and do some preliminary research and say ki mere paas itna masala hai to write a paper or not. Okay, that's it. So who are the 6 judges, Aman? Chief Justice.
Hello.
Yeah.
Chief Justice Sinha, who sat with Judges Imam, Judge Rao, Justice Shah, Justice Iyengar, and Justice Mudolkar.
Okay.
And two judgments were delivered as part of this forum.
Now, was the second judgment a dissenting judgment or was it a concurring judgment?
Ma'am, it was a concurring judgment that kind of differed on specific aspects.
Are you sure? Was it concurring or dissenting?
Well, actually, depending on what he said exactly, I would say dissenting.
Okay. So what is the difference between a dissenting judgment and a concurring judgment?
In my opinion,
Aman, you can speak once more and then I have to, my quota of speaking also.
Okay, so I'll reserve my quota for something.
Yeah. I will come back to you again, but for now. Okay. Now, those of you who've read the judgment, but before I leave you, Aman, how many judges did Chief Justice Sinha speak for? For himself and for many others?
He spoke for 4 others, and Justice Subba Rao wrote and delivered his own opinion.
Okay. So he spoke for 5 judges, right?
Yeah, himself and 4 others.
Yes, and then Chief Justice Subba Rao gave a separate judgment. Now that separate judgment, my question to you is, to the whole class, was it dissenting or was it concurring? Okay, now before I come there, those of you who read it from the case material would only find one judgment, which is Chief Justice Sinha's judgment. So obviously Arman and other people who have found out that there was a separate judgment have gone either to Indian Qanun, which is the free website, or they've read it off Manu Patra, or they've read it off SEC Online or Case Mine or whatever other one that you have access to. So when we look at a judgment, don't think, it's not wrong what we've put, but we also have limited space, right? So we've gone with the majority judgment, the leading judgment. We've excluded the separate. So that should be an eye-opener for those of you who thought that there is only one judgment of Chief Justice Sinha. Now my question, you went to India Qanun, yeah, Aman, good. Now my question, if there is a separate judgment, how will I know whether it is concurring or dissenting? Anybody? I don't want Aman, somebody else now to tell.
Ma'am, in this particular judgment, Justice Subba Rao gave dissenting.
Who is that speaking?
Ma'am, I am Mitansh Gupta.
Yeah, Mitansh, tell me.
Ma'am, Justice Subba Rao gave dissenting judgment in this case.
So what's the difference between concurring and dissenting? Aman, please turn off your camera. Yeah, what's the difference between concurring and dissenting?
Ma'am, as the name suggests, I can infer that dissenting means, of course, he's not, his views are different from what are there in the majority. Like Justice Subbarao said that federalism state property should not be taken by the center, while other said that it is quasi-federal.
And in concurring, what's the difference between the majority judgment and concurring judgment?
Sorry, ma'am, I have no idea for this.
Okay, dissenting means you disagree. You are a dissenter. What is the difference between the majority judgment and the concurring judgment? Anybody else?
Ma'am, the major difference lies in the reasoning that the judges give. So the ratio is same in the majority judgment and the concurring judgment, but the reasoning for the judges.
Runjan, if the reasoning is different, can the ratio be the same?
Yes, ma'am. Ma'am, for example, even in the Justice case, Puttaswamy case, we see there were different concurring judgments. Like they use different proportionality standards. They gave as to what right.
So, wait a minute. The ratio of the entire judgment of all the 6 judges or all the 9 judges, if it were Justice Puttaswamy case, will be culled out by looking at all the judgments as a whole. Okay, and seeing that on this point the ratio was 3:2, on that point it was 6:4, etc., etc. But the decision will be the same, but the reasoning will be different. The ratio of each individual judgment will also be different because the ratio is the reasoning. But when you say ratio of the entire judgment as a whole, a subsequent bench will pull out one single ratio. And usually that ratio will be based on what the leading judgment or the majority judgment says. Now, I think you may want to reformulate Runjan by saying that the decision or the outcome of Justice Subbarao, if it had been the same as Chief Justice Sinha, to say that the Coal Bearing Areas Act is intra-virus to the Constitution, then it would have been a concurring judgment. But Justice Subbarao took the view that this law was ultra-virus, whereas Chief Justice Sinha took the view that it was intra-virus. So it was dissenting. In concurring, the decision is the same, but the reasonings are different. Like, let's take a simple case from constitutional law. Let's look at family law. Question is whether man is entitled to divorce his wife. If the majority judgment says yes, he is entitled to divorce, but these are the grounds. Somebody else also says yes, he is entitled to divorce, then it will become a concurring judgment but with separate reasons. Somebody who says no, he is not entitled to divorce will become the dissent. So the dissent or concurring is really based on the decision and the reasons will be different. Okay. Ratio will be different. So Runjan, look at your understanding of ratio once again. Okay. Somebody says, Sakshi, turn off your mic. Yeah, so Sakshi, turn off your mic. Yeah. Creating some noise for the others. Okay. Now let's come on to the facts of this particular case. So I'm going to call upon, let me come to the D's. Divyanshi Maurya. Divyanshi Maurya, are you there?
Yes, ma'am.
Tell us the facts of State of West Bengal versus Union of India. Have you read the case, my dear?
Ma'am, I haven't read this. Actually, I was completing the previous cases also.
Okay, so then that's okay. Then I'm going to ask Gaganpreet Kaur. Have you read the case? Can you tell us the facts, Gaganpreet? Gaganpreet. You have to say yes or no. You can't be silent. Gaganpreet Kaur. No, you haven't read. Okay. Okay. Have you seen this film Legally Blonde? Himanshu Bhatti. Tell us the facts. Himanshu Bhatti. Are you there, Himanshu Bhatti? Okay. Okay, Himanshu Bhattu, just try and get back in. I'll let you in. Okay, who else is? I by mistake logged him out when I was clicking his name. Indrajit Prabhakaran. Indrajit Prabhakaran. Indrajit Prabhakaran, are you there? Okay, who can tell me the facts? This is Indrajit Prabhakaran. Why haven't you read the case? Not good. Jahnavi Miglan.
Ma'am, I haven't read. I've just started taking your classes. It's my first class today.
Okay, S. Ambika, have you read it? S. Ambika.
Ma'am, if I may exhaust my...
No. I have to ask somebody else. Who has read the case and can tell me the facts?
Ma'am, may I? Ma'am,
Who is that?
Ma'am, Mitansh.
Mitansh, no, you've spoken before. I want.
May I say
Ma'am, can I?
No, Ankita. Okay, Ankita, let's hear you on.
Yes, ma'am. Ma'am,
Okay, don't others. I have nothing against you both. Just that I want more and more people to speak. Because if you don't speak in class, you will get more and more nervous because there's also an opportunity to public speak and a lawyer needs to build up confidence, okay? So these classes, tutorial classes of presentation, I want more people to speak. And there's no big deal in speaking. Speak in English, speak in Hindi, no problem. Even if I stop and question, don't feel nervous. This is just like our own home. This is a class. Ankita, go ahead.
yes, ma'am. Ma'am, so State of West Bengal has filed a suit under the Article 131.
Okay, now just stop there. Why have they filed a suit and not a writ petition? Is a suit, can it be filed in the Constitution? I thought suits are filed only in the CPC, under the CPC.
Yes, ma'am. The suit can be filed under constitutional law as well, and as well as CPC.
Okay, so which is the provision? Did you look at 131?
Yes, ma'am. Article 131 of Constitution of India relates to original jurisdiction of Supreme.
Very good, very good. So, under the original jurisdiction, you will file a suit. Let me just go off a little bit in a tangent here, Ankita, and ask you a question. Normally, you've studied the Code of Civil Procedure, isn't it?
Ma'am, this is the first semester that we are studying CPC, and we have had only 2 classes. Today's going to be
Okay, no problem. But generally speaking, in the CPC, we will be following the Suit Valuation Act. We will be following court fees. All these things will have to be paid when you file a suit in a normal court. So the suit will be valuated. So if it is a jurisdiction of 1 lakh, the pecuniary jurisdiction will tell you at which level of court to file. The court fees will have to be paid, and then you will file a suit. So if it is a defamation case and you're asking for 1 crore, then in Delhi they will say you must give at least 5%. So you will be paying 5 lakh of rupees or 1 lakh of rupees, maybe it's changed now, as court fees before. If it is pecuniary jurisdiction of 1 crore, you won't be able to file it in 30,000. They will say go to the Delhi High Court and file it because 1 crore jurisdiction. So 5 crore is now lifted a bit higher for High Court, but that will determine. When it comes to the Supreme Court, I'm just going to elaborate a bit. It's not in West Bengal. These Article 131, we'll look at it in detail when I come to the unit on judiciary, but since it's come up here, please note that a suit is filed by one state against another state, or one state, okay, 2 crores, okay, you think, I also think, okay, but no, I know how to say sure. But state versus Union of India versus a state, X-state versus Y-state. And so this is State of West Bengal versus Union of India. But we have had other very, very historic cases, and one of the most celebrated cases was State of Punjab versus State of Haryana over the sharing of the Yamuna waters. Okay, State of Karnataka versus State of Andhra Pradesh. Almaty Dam. So interstate river water disputes usually end up under Article 131. Yes, Ankita, sorry for that interruption. I wanted to use this opportunity. So West Bengal filed the suit under 131 against the Union of India. Please continue, Ankita.
Against Union of India for a declaration that Parliament of India, that is the legislature, is not competent enough to make laws that authorize the Union of India to acquire a property or any land or any right over that property that is belonging to a state. So the property of the state, the Union of India has no competence to make laws to acquire that land, or in that matter.
Then I'm just going to stop you here and put a question to you. When we say the Parliament of India has no competence to make a law, what does that mean? It means that the Parliament does not make laws? Is that what it means? Are we saying Parliament cannot make a law? Or are we saying it cannot make this particular law?
Yeah, ma'am, Parliament can make laws, but not this particular law that authorizes it to acquire the land of the state, of any state under it.
So, just if I leave the facts for a moment, when we say you lack legislative competence to make this law, what would be the broad things that you would be having in mind when you make a contention like this, Ankita?
Ma'am, when we say that that Parliament of India is not having the legislative competence to make law, I think is that Parliament of India is cannot make such laws whatever the competence it is not having. So if in this case,
so then let me just interrupt you once again. That is, we are wanting to say that Parliament has the capacity to make law, but it lacks the subject matter jurisdiction or subject matter competence to make a law with regard to acquiring land which is belonging to the state. Right?
Yes,
there is other kinds of laws, but a law acquiring land which belongs to the state, it cannot do. Okay, then what else is there about the facts that you want to tell us?
Ma'am, this is pretty much it. So the West Bengal has filed a suit in the Supreme Court, and then.
But I need you to tell me another thing. This is a broad thing. Was the virus of any law challenged in the suit?
Yes, ma'am.
Validity of any law. So that is also part of the facts. So which was the law?
Yes, ma'am. The Coal Bearing Areas Acquisition and Development Act of 1957, which was enacted by the Parliament to acquire the coal bearing areas of whole of India, the whole of territory of India. So this act was enacted by the Parliament, and the respected Advocate General of West Bengal said that the Parliament went ultra vires while enacting this particular law. Act.
So, not only did they want a declaration, I'm now coming straight from the facts to the relief, okay? Not only did they want a declaration that Parliament was not competent to enact the law, they went one step further and they wanted the court to declare this law to be ultra vires. Am I right?
Yes, ma'am.
Okay. Now, because we're all students of law, you can see the subtle difference. One is to say that this law is not lawful, to declare that you don't have competence. The second is to hold that particular law, which is under challenge, to hold it to be ultra vires. Now, not Ankita, anybody else, when we say this 1957 Coal Bearing Areas Acquisition and Development Act 1957 is under challenge, is there any other legal phrase that we use to indicate that when we use to say that this is the law that is under challenge? Is there any other phrase that you have come across?
Ma'am,
impugned legislation.
Impugned, very good. Impugned legislation, okay? The impugned legislation. So that's a short form for telling us that this is That was you, Prithviraj? Was that you? Who
Ma'am,
said
it was
Yes, ma'am. Ankita also.
Ankita and Prithviraj, both good. So impugned legislation, as you know, means that law is under challenge. So I don't have to go to this long-winded, wordy explanation to say the law under blah, 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 blah. I just say impugned, and then I know already that the law is under challenge. And with what type of challenge? A challenge regarding its constitutionality, a challenge regarding its validity. So the impugned legislation is the coal-bearing areas, acquisition, etc., etc. Okay, and therefore these were the reliefs sought. Okay, thanks Ankita, thanks Prithviraj. Now I want somebody else to tell me what were the legal contentions on behalf of the state of West Bengal. Contentions.
Ma'am, the legal contentions of the state was
Yeah.
the first one was state sovereignty,
Okay, state
in which it is yes, ma'am, in which it was said that constitution being federal, the state share in the sovereignty, and parliament cannot take away these state rights.
Okay, but I need you to go a little more in detail. This is too broad. They had a nice little argument distinguishing political sovereignty and legal sovereignty. Do you recall? They talked about legal sovereignty and political sovereignty.
Yes, ma'am.
Yes? Himanshu?
Yes, ma'am. I'm not able to recall it, sir.
Ma'am, this is the political sovereignty lies in parliament.
Who would like to talk to me about the contention? I'm taking up now one contention about the distinction between political and legal sovereignty. Mitansh, you want to speak?
Yes, ma'am. Contention was that legal sovereignty lies within the people and political sovereignty lies within the parliament.
No, is that what West Bengal said? Don't tell me what the court said. I don't want the final decision. I want the contention of West Bengal. What was the contention of West Bengal on this point? West Bengal's contention was that sovereignty in a federal constitution, there would be two sovereigns. There would be a central government which is sovereign, and then there would be a state government that is sovereign. Okay? And that was the key issue in this case. Can there be dual sovereignty in India, that of the center as well as that of the state? And they called this a political sovereignty. And they distinguished this from legal sovereignty. We, the people of India, have given to ourselves this constitution. That gives the understanding that it is the people who are sovereign and who have adopted the constitution. Yet political sovereignty, in the sense of having the ability to create laws that will restrict the rights or create liabilities for the people, that sovereign power, West Bengal and the Advocate General for West Bengal had argued that there is both a central and a state, both of them having sovereignty. This was the contention. Am I right, Himanshu?
Yes, ma'am. Yes, ma'am.
Okay. I would like now somebody to tell me about the contention that this law, okay, there was a contention now from the government side that this Coal Bearing Areas Act was not acquiring the land, but was merely acquiring the lease over land. What is the distinction and what was that argument actually about? That is, was the Coal Areas Act a law acquiring land, or was it only acquiring the lease over land, over coal, which was not being worked? Anybody who read the case closely, can you come across any distinction like this? No? Fine. Okay. Was there any contention with regard to the statement of objects and reasons? Any contention with regard to statement of objects and yes, Rahul, tell me. Rahul, the contention with regard to statement of objects and reasons.
Yes, ma'am. In the on Indian Canon, I have read that the preamble of the Act did not support the argument that the Act was intended to acquire only the rights of individuals and not those of these states in coal-bearing areas. Though the statement of object and reason supported.
No, don't read from the judgment to me. Explain to me what was West Bengal's contention with regard to the reasons. Or I'll put it to you another way. The statement of objects and reasons said one thing, but the actual body of the act said something slightly different. Okay?
Yes, ma'am.
So they were making. So who was that who said yes?
Ma'am, Ankita.
Yeah, Ankita, what's the difference between the two?
Ma'am, Supreme Court said that the statement of objects and reasons, which are tabled along with the bill, when introduced in Parliament, they alone doesn't define the objective of the Act. We have to take the substantive objects of the Act and we have to read the Act together with the bill so as to definitely imply what the Act want to achieve ultimately.
Good, which means that when we are doing interpretation of a statute or constitutional interpretation, the statement of objects and reasons stands outside the Act. It is not actually part of the Act. It is just that accompanying statement that accompanies what the minister wants to say when he or she is tabling that bill in Parliament. It gives you the objective of the government or the executive which is piloting that bill in Parliament. Now, the minister can say one thing, but when the court is interpreting what is the object of the Act, it will first look at the provisions of the Act, look at it as a whole, and the statement of object and reasons is only a guide which may influence what the eventual object of the Act is, but they will be guided mainly by the provisions of the Act and rather than the provisions of the SOR. So somebody can say something else in the statement of object and reason. That is not conclusive. What is conclusive is the provisions of the bill itself. Now, if this is the principle of statutory construction, then the question is, what is the difference that the minister said in the statement of objects and reasons and what is the difference in the actual provisions of the coal-bearing bill? Let me expand it. Yes, Aman, what is the difference between the preamble and the statement of objects and reasons? Please answer that to me before we come to the case. What is the difference between the statement of objects and reasons and the preamble of the Act?
Well, so now the statement of objects and reasons, the court found that was laid down by
this case. Let's first decide what is the preamble, what is the SOR. What's the difference between SOR and preamble?
Okay, so the SOR is even prior to it becoming an Act. Right? Okay. So it is suggested, as you also said, by the minister or the group of ministers that lay down the Act for its discussion.
So every bill is accompanied by the SOR. But is the SOR part of the bill or the Act?
No, it isn't.
It isn't part of the Act as eventually adopted. It is there. What is the preamble?
The preamble in this case is what lays down.
There are another word sometimes used for the preamble.
I think sometimes they use short title.
No, use it as the long title. The long title.
Okay, sorry, long title. Yeah.
Okay, so that is an act to provide for succession of Hindus, blah blah blah, would be the long title. Then section 1 will say short title. This act may be known as the Hindu Succession Act. And that long title, sometimes some judgments refer to it as the preamble. Okay? Right. Now, was there a difference between what the preamble said on the one hand and what the provisions of the Act said on the other? Aman?
Yes, ma'am, because the preamble said that the statement of objects and reasons said that they did not intend to acquire the proprietary rights vested in the state, right? Whereas the preamble made it clear that for establishing economic interest in India, there was a need for greater public control over the coal mining industry and its development, and it provided for the acquisition of unworked land.
Unworked. Very good, very good. Now look at this point. Look at this point that we are discussing, the rest of you. The SOR says, the minister says that without affecting the proprietary rights, meaning the state as a property owner, they don't want to tamper with the proprietary rights of the state. That's what the statement of objects and reasons says. But the bill, the actual act as adopted in the long title of preamble says that the union government wants to take over the unworked mines. That is, there's a lot of coal underneath, but those mine licenses haven't been given out. They're sitting wasted because the government wants to increase its coal capacity. You know that India has the largest coal reserves in the whole world, and therefore to enact this, that they want to take over that land. Now you can see the tension here. Now as a good lawyer, this is the kind of way in which you will read it closely. Where is it that I can find out a case for my client? That the SOR, they say we don't want to tamper with the proprietary powers of the state or the property rights of the state. And then the long title straight away says, in order to give the power of the union to take over those unworked mines, meaning you're wanting to acquire that property. So SOR says we don't want to acquire property, but the actual provisions of the Act say that you want to acquire property. So what is the true intention of this Act? So there's a contention being built up here. Now what am I trying to do? I know it's 1:27, so I should probably stop. I'm just trying to show you that we must read very, very closely and try and see where it is. What I'm going to do is, I know, Mansi, that I have to take attendance. The thing is that the attendance is being taken in that system, and there is something that I'm downloading, but I think that I'm not so tech savvy. So I'm a little concerned because people come and go and I'm not very clear. So I'm taking the attendance in this little old fashioned way. But I also have a backup of that. So I am going to take attendance. So I'm going to continue with this case tomorrow. I would like all of you to read it, please, in this very careful way. I'm going to continue with the contentions of West Bengal, and then I'm going to straight away come to the judgment of Justice Sinha. And understanding what is the nature of our constitution. Because why is it that we are reading this case? We are looking to see whether the constitution gives the power of the sovereignty. Does it give political sovereignty to the state or not? That's the real question we want to ask. And number two, if the political sovereignty is not there in the state, are we still a federal or a federal constitution? And the third question that I want you to understand is, recently, after that, what are the current laws that govern acquisition of coal mines? You know that just before the lockdown, Parliament enacted the Coal Mines Special Provisions Act, an amendment to the 2015 Act. You know that the coal is a very hot topic currently. Right after the 2G spectrum, the coal licenses got cancelled. The law itself has changed very, very profoundly now. So just by way of updating the background knowledge, you can also read that. I would like everybody, please take time. It's about 15-20 pages. I would like everybody to read it and read it closely, underline it or whatever, make comments, make that case brief and come for tomorrow. You will find that reading a judgment closely, एक है one कहानी type you can read, जैसे दुक्की में आता है ना, इतना सा. You can read it Dukki style. Your learning will also be Dukki style. Okay. But if you want to read it closely to understand how, as a lawyer, if you wanted to draft a bit or a suit, so there are grounds A to H, एक point को बारीकी से देखकर, how will you make your point? So please read it carefully and come tomorrow. I'm now going to take my attendance. Constitution. Priyasha, are you here? Are you present in class today? Priyasha? Okay, now we were looking at Article 1 of our Constitution. It says, India, that is Bharat, shall be a union of states. In my class yesterday, we went...
दोस्तों, ब्राज ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें। थैंक्स फॉर वॉचिंग।